Hello. Today we're going to talk about the 1987 Philippine Constitution's key doctrines for the 2025 bar. Let's start. General principles. The doctrine of supremacy of the Constitution. This means that the Constitution is the fundamental and paramount law. All laws and acts inconsistent with it are void. The court has the duty to strike down unconstitutional acts. Bar tip: always cite supremacy when invalidating statutes or executive acts. Now, this doctrine was upheld in Angara versus Electoral Commission. As to state policies, most provisions in Article 2 are not self-executing. They serve only as guidelines for legislation. Example, right to balanced ecology and right to health. The exceptions are: some may be judicially enforceable if the language is mandatory, such as shall protect and advance the right of the people to a balanced and healthful ecology. This was upheld in Oposa versus Factoran. Now let's go to Bill of Rights, Article 3. In the doctrine of due process and equal protection, this emphasizes that reasonable classification must, first, rest on substantial distinctions. Second, it must be germane to the purpose of the law. Third, it is not limited to existing conditions only. And fourth, it must apply equally to all in the same class. This was upheld in People versus Kayat. Furthermore, under Ermita Malate Hotel versus City Mayor, it emphasizes that due process requires fairness and presumption of validity of regulations, unless proven arbitrary. In the ex post facto law and Bill of Attainder, these doctrines are both absolutely prohibited. A Bill of Attainder is a legislative act that inflicts punishment without judicial trial. This was emphasized in People versus Ferrer. In the doctrine of freedom of expression, under the case of Chavez versus Gonzalez, it is emphasized that prior restraint on speech is generally invalid. This can only be allowed under a clear and present danger test. Furthermore, political ads cannot be banned absolutely. Such prohibition is unconstitutional prior to restraint. This was cited in ABS-CBN versus Comelec. In the doctrine freedom of religion, there are three tests applied: Lemon test, benevolent neutrality, and strict scrutiny. Under Lemon test, government action must have a secular purpose and not advance or inhibit religion, and should not excessively entangle the state with religion. This is under the case of Lemon versus Kritzman. For benevolent neutrality doctrine, religious freedom may justify exemption from general law if no compelling state interest exists. This was upheld in Estrada versus Escritor. And finally, the application is only if a law substantially burdens religious exercise. And this is under the strict scrutiny doctrine in Iglesia ni Cristo versus CA. As for searches and seizure, it emphasized that checkpoints are valid if conducted to serve public order and is not discriminatory. This is under Valmonte versus De Villa. Also, warrantless searches must fall under recognized exceptions, and these are: 1. Consented search; 2. Incidental to lawful arrest; 3. Stop and frisk; 4. Moving vehicle; and 5. The plain view doctrine. This was under People versus Doria. As to right to privacy, it emphasized that the right to privacy is an independent constitutional right protected under liberty and due process clauses. under Ople versus Torre. And finally, in the self-incrimination doctrine, this applies only to testimonial compulsion and not to physical evidence such as fingerprints, handwriting, and DNA. This was under People versus Ison. As for the legislative department under Article 6, in the Enrolled Bill doctrine, it highlights that courts will not go beyond the enrolled bill duly signed by the presiding officers. It is conclusive on the contents of the law, highlighted under Astorga versus Villegas. On the one subject, one title rule, it emphasizes that title need only express the subject in general terms and does not need to be an index. Tolentino versus Secretary of Finance. As for origination clause, this says that revenue, tariff, and appropriation bills must start in the House, but the Senate may amend it. Now let's go to the Executive Department under Article 7. In the doctrine of qualified political agency, this highlighted that the acts of cabinet members are presumed acts of the President unless disapproved, under Villena versus Secretary of Interior. Also, executive privilege means that the President may invoke privilege for state secrets or diplomatic military matters, but cannot issue a blanket prohibition against officials attending hearings. This was under Senate versus Ermita. And as for pardoning power, this covers pardon, commutation, reprieve, remission of fines, but it excludes, excludes impeachment, civil contempt, election offenses. This is under the case of Monsanto versus Factora. For the Judiciary Department under Article 8, we have the expanded judicial power, which means that courts may strike down acts of any branch or instrumentality that constitute grave abuse of discretion under the Francisco versus House of Representative case. As for political question doctrine, it highlights that this is no longer a barrier if there is a grave abuse. Daza versus Singson. For judicial review requisites, these are the requisites. 1, there must be an actual case or controversy. 2, there is a proper party. 3, it is raised at earliest opportunity. And 4th, resolution is lis mota under Angara versus Electoral Commission. And finally, for judicial stability, lower courts cannot interfere with higher courts' decisions. Let's go to the constitutional commissions under Article 9. First, doctrine emphasized is independence. Their independence is constitutionally protected, therefore Congress cannot reduce their powers. As for Civil Service Commission cases, the security of tenure applies even in GOCCs under Gloria versus CA. And for the COMELEC, it has the primary jurisdiction in election disputes, but such is subject to Supreme Court review. Aratuk versus COMELEC. For the local government under Article 10, LGUs cannot interfere with national government franchises unless delegated by law. Basco versus Pagcor. And LGUs have delegated power of eminent domain and taxation. This is enshrined in the local government code. For the accountability of public officers under Article 11, for impeachment, this applies only to President, Vice President, Supreme Court Justices, members of constitutional commissions, and Ombudsman. Now, as for the Sandigan Bayan jurisdiction, This covers public officials with salary grade 27 and above and cases involving graft. This is under People versus Sandigan Bayan. Now, as for doctrine of command responsibility, the administrative liability of superiors for failure to supervise subordinates is emphasized. This is under Lacson versus Executive Secretary. Now, under National Economy and Patrimony, Article 12, in Gamboa versus Teves, the term capital in the 60-40 Filipino foreign ownership rule means both voting and full outstanding capital stock. Also, foreigners cannot own lands except by hereditary succession. This is under Krivenko versus Registry of Deeds. Under education and academic freedom, that is in Article 14, academic freedom gives the schools the right to determine standards of admission and graduation. This is under Garcia versus Loyola School of Theology. And then in amendments and revisions under Article 8, there are three modes of change that the Constitution provides. Number one, Congress as constitutional or constituent assembly. Second, Constitutional Convention. And third, People's Initiative. However, under Santiago versus Comelec, it is emphasized that People's Initiative for constitutional revision is not allowed under RA 6735. People's Initiative for constitutional revision is not allowed, but only for amendments. So if you find this video substantial and useful, don't forget to like, share, and subscribe. Daghang salamat!